Why shouldn't I hold you in willful contempt?
Okay, so I'm going to explain everything that happened.
Was your verdict on March the 2nd, 2023 in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am.
Apparently your wife showed up in court on October 30th. That was the day before you dyed your hair, if I remember correctly.
The drama in a courtroom doesn't just rest with the attorneys and the facts of the case. No, sometimes the spotlight is put on the jurors. We break down some memorable juror moments in recent trials that we covered here on Law and Crime. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. You know who we don't talk about enough here on Sidebar? We talk about defendants, we talk about witnesses, we talk about the attorneys, the judges. What about the jurors? We don't talk about them enough. Arguably the most important members of a trial. Unless it's a bench trial where the judge decides the verdict, the jurors are the triers of fact. They weigh the evidence. They determine if someone is guilty or not guilty, liable or not liable, whether someone should be put to death or sentenced to life in prison. And as we have seen several times over the course of trials that we've covered, it is sometimes the jurors who are put in the spotlight for interesting and memorable reasons. And that's what we're going to get into. So I think the best place to start is with the Young Thug trial. Now, we've talked about this trial a lot here on Sidebar because of a lot of, for lack of a better words, shenanigans. I think that's the best way to say it. I mean, this is a trial that had a jury selection process that took almost a year. This, of course, is the criminal trial of the rapper Jeffrey Williams, who's been accused of being the leader of a criminal gang known as YSL. He and his co-defendants have been charged with violating the state's RICO statute, among other charges. That's racketeering. Ideas that this is a criminal enterprise. The members committed all sorts of crimes, including murder, to further the gang. The defense suggesting there is no gang here. This is just a record label. And this trial is ongoing at the time of this recording. We're already past 80 days of this trial. But let's talk about the issues surrounding the potential jurors during the jury selection process that I mentioned. So I saw things that I can't say I've ever really seen before. The reason I say that is because Judge Earl Glanville, who is overseeing this trial, he does not mess around when it comes to his rulings and the court rules. I don't say that lightly. For example, a prospective juror improperly recorded the jury selection process proceedings on her phone. Judge Glanville had her arrested. Let's go back to April 2023.
Why shouldn't I hold you in willful contempt?
Okay, so I'm going to explain everything that happened that day on the 17th of March.
Okay, but before then, do you recall this court giving you the ad nauseum admonitions about acceptable behavior?
About having phones out?
Yes.
At the moment when we came in.
Didn't I tell you to turn your phone off?
It was, I'm going to be truthfully and very honest. When it was a lot going on, we had just come from different
Answer
floors.
my question first, and then you can explain it. Do you recall us telling you to turn off your cell phones?
Yes, sir.
Okay. You also recall me going through a litany of different things that would cause us to potentially put the case in jeopardy. Do you remember me saying that to you?
I mean, I couldn't hear. It was so much people. It was so many people talking and so many people doing different things. So people were talking when I was giving that admonition to you? Yes.
Meaning that you didn't hear it? You didn't
Yes.
hear any of the 10 minutes that I went through on the record about the things you couldn't do? Specifically, you couldn't research on Google. You couldn't go ahead and otherwise contact your friends on social media. Do you remember that?
Well, I remember the part when you're saying we had to, but I didn't hear the turn off the phone.
You remember me talking about no social media?
Yes.
Do you remember me also pointing to the placards that are on the wall about social media and the things you cannot do?
And I didn't see that until after the fact.
You don't recall me pointing that out to you?
No, sir.
You do remember you couldn't otherwise post, pin, tweet, or otherwise.
And I didn't.
Send anything to social media.
Correct, I didn't.
But you did live stream our proceedings, didn't you?
It wasn't live streamed at all.
So what exactly did you do then?
Okay, so when you was giving the speech, everybody was talking. I did take a video, and then the young lady next to me, she was like, "Ma'am, we're not supposed to be recording." Soon as they said that, I deleted everything right then and there. Maybe an hour went by. That's when the officer came up to me and said, somebody had told us that you may be recording. So I showed them the phone. They went through my recent deleted photos and seen the video that I made. But it was already deleted because the young lady next to me had told me that you did say we wasn't supposed to be doing any of that. And this is my first time. That was my first time ever being in court in my whole entire life. So I wasn't really sure of anything we couldn't and could not do. So I do apologize for that.
Madam, I went through a very long and arduous process of telling people what they could not do.
Correct.
And you violated that. And you put this trial in jeopardy. I'm going to sentence you to 3 days of in jail, and that will otherwise satisfy your contempt. You videotaped our proceedings. It was just a brazen violation of these particular proceedings. I told you not to. If you just left your purse in your pocket, you would have not even put yourself in this particular predicament.
Right, but it was so much going on. I suffered.
That doesn't excuse your behavior, and doesn't give you.
I didn't hear every.
Madam, that does not excuse your behavior, and it doesn't provide it's an excuse for behavior.
Got to turn those phones off. And worse off, recording the jury selection process. It's already tough getting a fair and impartial jury in this kind of case, which defendants are entitled to. So the judge is right. A juror improperly recording this process is a major, major issue. Judge Glanville explained that a punishment, like a sentence here of 3 days in jail, we do that for a variety of reasons, to deter her, to deter others from doing this, rehabilitation, reentry into society, retribution. Now, while Judge Glanville did sentence her to 3 days in jail, she was actually released after 5 hours. I have a feeling at the end of the day she learned her lesson, but that is not the only example. No, now let's talk about how one prospective juror apparently didn't return for jury duty during the jury selection process. She was on a trip in the Dominican Republic. Let's see how this plays out, because she explained she didn't see the jury duty notice until later on, and she had this trip already planned. And you're going to hear Judge Glanville's decision, which I tell you right now, you may not have guessed.
Actually, just receiving the jury summons. I travel a lot. I've always traveled a lot. Globally for work and other things, but I traveled. I wasn't here Thanksgiving week, the week of the 28th. And I don't think I returned until like the 16th. I was in the UK, and because I live with my grandmother, I didn't go because I was exposed to travel. Didn't want to make her sick, so I don't think I actually saw the summons until like the 30th.
The 30th of December.
Yes. And then at that day, when you said it, I asked when we were checking out, because it was a long day, I asked, was there any exception to the process? Because it was Wednesday, and the hardship things were on Monday. So I asked, my trip started on Friday, and it was a business-related trip, and I asked, was there any exception? They said the best she could do was send an email with the details and explanation. And I also knew I had these medical appointments. I have 5 weeks of scheduled infusions for the next 5 weeks starting the 20th upon my return. But they said send an email, and I did the first thing the next morning. I also called aggressively trying to get through. And that voicemail I called, I checked yesterday, it still says if you have an issue, send it with your jury summons, send an email, and you will not be penalized or something. So I sent that. I didn't really know I was in violation until the sheriff showed up. And even then he said, when you come back, come down. So after I realized it was I had a warning, that it was basically because family members started calling me from seeing the news or reading the paper or whatever.
Why didn't you just apply for a medical waiver? And if your health condition, you could have done that, and that would have earlier and gone ahead and not been in this particular position. But
because the jury summons said you had to do it 10 days before, I saw it really late.
So you're saying that when you had your, you didn't get because of your travel, that your notice sat in your grandma's home, and you may have heard me talk at the very beginning about the importance of jury service. We have a lot of people that we ask to serve. It doesn't make a difference what vocation or avocation you belong, or you have. It is that important. you know, it mirrors or is right up against that right, you know, your right to vote. So, when, you know, we take this very seriously in order to get a lawful and a fair and a just jury as to both sides. So, you know, there are a lot of people that were inconvenienced. I mean, severely inconvenienced. You're not the only person that outlaid money. I examined people yesterday who lost literally hundreds of thousands of dollars trying to be here, and I have to make decisions in regards to that. But I didn't even get a chance to examine you about your circumstance, because you went to, you know, you said, okay, I'm going to go, and you didn't afford me the opportunity to do that. What I think I'm going to do is, in order for you to satisfy your contempt, I'm going to commute the 20 days and require you to write a 30-page paper on the importance of jury service. Here's the criteria. You'll have to do APA style. You're going to have to use at least 10 primary sources, 10 secondary sources. You'll talk in a minimum, and I'll write this in the order.
Oh, okay.
You'll have an order. You'll have it before you leave here today. You're gonna write at a minimum, the history of jury service, who could not serve on a jury, because that's very important, because years ago, people that look like us couldn't serve on juries. It was prohibited. I want you to talk about jury service in Georgia and discrimination at a minimum, those 4 things, okay? And you can talk about anything else you want to, in that regard. I am going to give you a date 3 weeks hence that paper needs to be submitted to me electronically. And we're going to run it through a plagiarism checker. You got to write it yourself. And then you're going to come back and talk to me about it.
30-page paper. That is a punishment. Wow. It's better than jail time. But Judge Glanville said she shouldn't have just left. She should have figured out a way to bring this to the court's attention so they could have worked it out. But hey there, everybody. So I want to thank Morgan & Morgan for sponsoring this episode of Sidebar. Always love talking about them. Now, here is the incredible thing about Morgan & Morgan, and one of the reasons why I like talking about them so much.
Hey, say something about our big wins.
You're not supposed to come on camera. The reason Morgan & Morgan, America's largest personal injury law firm, is so big, and I'm sure you can guess it, is because they win a lot. And that's
Don't forget huge verdicts.
Yeah, they've won big verdicts. $6.8 million in New York, $26 million in Philadelphia. You see, the thing about them is they don't settle for lowball insurance offers from insurance companies, which is something.
Mention that you can submit a claim from your couch at home and on your phone.
Dan? They've completely modernized the process by submitting your claim, talking to your legal team. It's all done straight from your smartphone. Again, that's something that
8 clicks or less.
8 clicks or less. Yes. You can see if you have a case in just a few minutes.
Got 1,000 lawyers. We have over 1,000 lawyers.
All right. You know what, Dan? If you really think you can do better, maybe you should just do it yourself.
What Jesse was getting at is if you've ever been injured in an accident, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less. To start your claim, just visit forthepeople.com/LC Sidebar.
You came a little too close to me. It hurt me a little bit. I'm probably actually going to have to hire you guys now, but that was well said. That was well said. Let's move on to another high-profile case with jury issues. Alec Murdaugh, the disgraced former South Carolina attorney, went to trial in 2023 for the murders of his wife Maggie and son Paul, who were gunned down on the family property back in 2021. Prosecution didn't have a ton of forensics or even the murder weapon tying Murdaugh to the crime. They did have a bombshell piece of evidence, namely a recording taken off of the cell phone of his son Paul, placing Murdaugh at the crime scene only moments before the shootings. This after Murdaugh lied about his whereabouts. They also had inconsistent statements, his problematic testimony on the stand, an interesting motive that he killed his family to distract away from his other crimes. You see, he stole from his law firm and clients, and there was also a pending lawsuit against him. And the idea was that he would buy himself time, distract away from all that. Well, in the end, the prosecution's case worked because Murdaugh was convicted. He was sentenced to life in prison. He was also sentenced to an additional 40 years in a separate case for his financial crimes. But there were a number of juror issues that I want to get into. So the first one is actually quite comical. It concerned juror number 785, who was accused of speaking about the case as the trial was going on and was dismissed. But as Judge Clifton Newman excused her, listen to what she brought with her to court.
And in fairness to all the parties involved, we're going to replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs?
Yeah, one of the other jurors brought in eggs for everybody from the farm.
Okay.
Eggs, my purse, and nut water.
All right, well, you're going to leave the eggs? You want to leave the eggs or take the eggs? You're going to take the eggs. So, Mr. Bailiff, can you retrieve from the jury room her dozen eggs, her purse, and what else? And a bottle of water. If you can get those things from the jury room. So they're going to get your things, and then once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. You can go. Thank you. We get a lot of interesting things, but now a dozen eggs. It's certainly pretty interesting.
Can never be too careful. When hunger strikes, you got to have some eggs ready. Who can blame her? Now, while that was a bit comical in an otherwise very dark case, it turns out this juror actually played a role in another issue I'm about to talk about. You see, after the trial, the defense argued that Murdaugh was entitled to a new trial. Why? They argued that the court clerk, Rebecca Hill, had inappropriate communications with the jurors, namely trying to influence them to find Alec Murdaugh guilty. Yeah, they argued that Hill had a book deal, an incentive to make sure Alec Murdaugh was convicted. And one of the more alarming allegations was that Hill intentionally got this egg juror booted from the jury after she allegedly told Hill she had questions about whether Murdaugh is actually guilty. The defense alleged that Hill fabricated a Facebook post authored by the juror's ex-husband, a post that said he talked to the juror, his ex-wife, about the case. Defense says the ex-husband never posted it. But again, this juror was dismissed. And the defense said they spoke to several jurors, and there were issues like Hill allegedly telling the jurors not to believe Murdaugh's testimony. So what happened? A hearing was held to determine what is going on and whether Alec Murdaugh should be entitled to a new trial. Let's hear what some of the jurors had to say.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There it is, but I can't remember.
Okay, that's fine. Was your verdict on March the 2nd, 2023, in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that. That's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right.
Can you get more of a bombshell than that? A decision was seemingly affected by Hill's apparent comments, but the juror also said that that decision was based entirely on the law and evidence in the case, and there seemed to be some conflict with what she wrote down in her affidavit, so this juror was brought back into the court.
When we began deliberations, Ms. Hill told us this shouldn't take us long, quote, and if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until after the deliberations were complete. Did you hear that?
Yes, ma'am.
Including the business about the smokers?
Yes, ma'am.
All right. Number 10, I had questions about Mr. Murdoch's guilt, but voted guilty because I felt pressured by the other jurors. Is that an accurate statement about your verdict?
Yes, ma'am.
All right. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show. Is that an accurate statement of what she said?
Yes, ma'am.
So you do stand by the affidavit?
Yes, ma'am.
Very good.
And there was more. Listen to this alternate juror.
In your affidavit, you said before the defense put up their case, Ms. Hill told the jurors, quote, the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off, unquote. Is this true? Did Ms. Hill say that?
That's exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we had assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in two
We was in two separate rooms, and when she came in, we all went in one room.
Okay. Paragraph number 5, Ms. Hill said, if you get emotional, we want to see your face because that is what they want to see. What does that mean?
She said, don't get nervous. Don't be afraid to show your emotions because that's what they want to see.
And then, to make matters even more confusing and problematic, apparently during this whole hearing, it was reported that some jurors might have been watching the proceedings. Yikes. In a case where we're trying to see if the jurors were improperly influenced in their verdict, are they now being improperly influenced by another juror's account?
Juror E, I understand that before I began to receive your testimony, that at the beginning when Juror Z was being examined, that some jurors may have had cell phones and accessed the proceedings. Did you have your cell phone?
No, ma'am.
Did you examine any cell phone broadcasts?
There was a couple people, but I have no clue what they were viewing.
Yes, sir. Okay. Did any of this activity by other people in viewing this material have any impact on you in terms of your testimony today?
No, ma'am.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
It was.
Did you hear Becky Hill, Clerk of Court for Clarendon County, make any comment about this case before your verdict?
I did. Yes, ma'am.
What did she say?
It was the day that Mr. Murdoch was taking the stand.
Yes, sir.
And she made a comment about watch his body language.
About watch his
body language.
His body language, I see.
Yes, ma'am.
And what else?
That's all I can recall.
All right, sir. Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the Clerk of Court, Becky Hill, in this case?
No.
But with all that, and after hearing from Becky Hill herself on the stand about what she did or did not say, this was the decision of Justice Jean Toll.
Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial. and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdoch's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered.
So Justice Toll had serious reservations and concerns about the behavior and testimony of Rebecca Hill, but found that what she allegedly did not have an impact on the verdict. No new trial for Alec Murdaugh. Now, in a similar vein, I want to talk about another potential issue of juror communications, and this was in the Take Care of Maya case. It concerns Maya Kowalski. So you might remember this one. She and her family had sued Johns Hopkins All Children's Hospital in Florida, claiming the hospital falsely imprisoned her, medically neglected her, caused her emotional distress, and fraudulently billed her after she was admitted to their care back in 2016. You see, Maya had a condition known as CRPS, complex regional pain syndrome. It's a neurological condition in which a person's body can misinterpret even light touches as excruciating pain. And the Kowalskis argued that the hospital ignored the family's instructions on how to treat Maya, as she had been in the past, and they cut Maya off from her family. I mean, she was just a child when this happened. And they said that as a result of what the hospital did, cutting the family off from their daughter, this ultimately resulted, the family said, in Maya's mother, Beata, taking her own life. Such a sad case. They claim that the hospital improperly contacted the Florida Department of Children and Family Services to suggest Beata had been abusing her daughter, which wasn't true. Maya didn't see her family for months. Maya said she was medically kidnapped. By the way, really, really sad case that was actually documented on the Netflix show, the Netflix documentary called Take Care of Maya. That's why we call it Take Care of Maya. Now, in the end, the jury sided with the Kowalskis, finding the hospital was liable, awarding a verdict of a whopping $260 million. Now, the judge overseeing the case, Judge Hunter Carroll, ultimately reduced the award to $213.5 million, but still massive nonetheless. But after the trial, the defense moved for a new trial. Why? They argued that juror number one, the foreperson, had improper communications about the case as it was going on, lied on the jury questionnaire, and even drew a Nazi symbol when taking notes regarding Dr. Sally Smith. She was the one who helped with the investigation into those claims of child abuse. Well, this juror appeared before the court. Let's hear what happened.
There seems to have been some sort of reference to child allegations involving this petition. So was there any sort of involvement by DCF more than 20 years ago in this case? When I say this case, the 2002 case.
No, there was not.
And at the time in 2002, did you have, how many minor children did you have?
2002?
2002.
That would have been 3.
Were any of your children sheltered by DCF or whatever the entity was called at the time?
None, no.
I told the assembled group that you couldn't even talk to your spouse or partner about the case And if they ask, that you were to say that Judge Carroll's a meanie and doesn't allow me to talk about this case. Were you able to follow that instruction throughout the entirety of the case until the time that you were discharged as a juror?
Yes, I was.
At any time until the time that you were discharged, right the day before Veterans Day or whatever day that was when we discharged you, at any time before that date, did you speak with anyone, that would include your wife, concerning anything having to do with this case?
No, I did not.
Apparently your wife showed up in court on October 30th. That was the day before you dyed your hair, if I remember correctly. Well, your hair went orange.
Yes.
For Halloween, I assumed. Okay, but let me go back to the day before that. Did you see your wife in court that day?
No, I did not.
Did you have any knowledge prior to October 30th that she was going to court?
Yes.
Okay. Tell me about that.
She told me that morning that she wants to go and sit in court, and I said, fine with me, and that was the end of the conversation.
Now, so you said you didn't see her in court?
Because of my eyesight, with my readers, because of my diabetic retinopathy, I only see figures in the gallery right now. I can't ID anybody.
Well, here's where I'm going with my ultimate question. I hear that you say you didn't see your wife, but I want to make sure, was there any sort of nonverbal contact or nonverbal communication from your wife to you about this case?
No, there was not.
Okay. At the end of the day, the defense has failed to demonstrate any juror misconduct. The court will therefore deny the motion for new trial based on alleged juror misconduct.
And there you have it. While there were issues about this juror, the judge was not convinced that there was anything that rose to the level of warranting a new trial. Seemed to believe this juror, and the verdict stands for now because the hospital still does plan to fight the case on appeal, so we'll see what happens there. Look, I will be the first to tell you, as somebody who covers trials all the time, trials are fascinating from a legal point of view. They're fascinating because they provide these compelling stories and narratives. But I'm also going to be honest with you. Sometimes they can be really boring, okay? I don't feel bad about saying that. Sometimes the testimony can be a bit dry, okay? Sometimes sitting there hour on end can be tiring. Are we surprised that jurors then fall asleep? Well, that is what was alleged in the trial of Kevin Dean Eastman, the man who prosecutors say murdered his ex-girlfriend, Heather Frank, and her new love interest, Stanley Scott Sessions, out in Colorado. And right after the opening statements, the defense brought up this major issue.
Outside the presence of the jury, and Ms. Devereaux had an issue she wanted to raise. Ms. Devereaux?
Your Honor, just that we noticed Juror 13 was falling asleep during openings. There was a point where we watched her be asleep for about 45 seconds. We're not asking for anything at this time other than if the court could maybe invite the jurors to make sure they're doing whatever they need to do to stay awake and carefully listening to the evidence. Whether that's coffee, breaks, I'm not sure what the problem is, maybe inquiring with her independently and seeing what her situation is, if she's able to pay close attention this morning, or if she's experiencing something in her personal life that's preventing her from being able to do so. But that's all we're requesting at this time.
Mr. Runn?
I did not observe it, so I don't have any additional comment or information.
I didn't observe it either. I will monitor that, and if it's necessary, we will have a discussion with juror number 13. But at this point, I'm not going to take any further action or make any statements until I observe it and believe that there's a concern that juror 13 is not paying attention. Okay, let's bring the jurors in. When the jurors come in, if everybody can please rise.
Now, if that is true, can you see the defense's concern? Not even during the middle of this trial, or not even during the course of, I don't know, cell phone testimony or DNA evidence. The opening statements, that's when somebody allegedly falls asleep right at the beginning when you're laying out the case. It's usually when jurors are glued to what's happening. It's the start of the trial. But again, we don't know if it really happened. We don't know if the juror fell asleep. Prosecutors, the judge, they didn't see it. And I don't really recall anything really coming more of that. But in the end, the jurors came back. They found Mr. Eastman guilty, and he was sentenced to life in prison. But let's keep on that theme of the jurors' health for a moment and go to San Antonio, Texas, because this is the capital murder trial of former Border Patrol agent Juan David Ortiz. Now, Ortiz was accused of killing 4 women: Griselda Alicia Hernandez, Claudine Ann Luera, Janelle Ortiz, and Melissa Ramirez. A 5th woman, identified as Erica Pena, was able to get away from Ortiz, ran to police. Ortiz was arrested. Ortiz apparently confessed to authorities about this, saying his goal was to, quote, clean up the streets from sex workers. Well, at one point during the trial, Webb County Chief Medical Examiner Dr. Corinne Scott took the stand and was going over the autopsy findings. Now, of course, anyone knows that this can be very, very tough testimony to handle. Learning about the details of someone's death, seeing the graphic autopsy photos, it's not easy. And it turns out, for one juror in the Ortiz trial, it may have been a little bit too much to handle because that juror actually fainted in court. Take a look.
Yes, that's the bullet I recovered under the left ear and the upper part of the neck.
Now, I'm going to refer you to your gunshot wound of the neck, injury number 3.
Okay, so she had another gunshot entrance wound on the right side of the neck above the one we just described. It was also a round defect, and she also had
We'll go ahead and excuse at least a juror. You want to help him out? Can you excuse him for now? Out there, maybe. We'll go ahead and excuse the jury just for a few minutes. Remind him not to discuss the facts of the case. He can be seated. He doesn't have to stand just yet. Let him. But everyone else can step up. You want to go? Let the jurors walk out first.
Yeah, as Dr. Stern was going over an autopsy photo and you see members of the gallery crying, this male juror fainted. In the end, though, he was okay. But Judge Oscar Hale dismissed the juror and replaced him with an alternate. No surprise there. Not easy sitting on a juror. Remember, these aren't necessarily people who see this kind of stuff on a daily basis or ever. In terms of Mr. Ortiz, he was convicted of capital murder and sentenced to life in prison without parole. That's all we have for you here on Sidebar, everybody. Thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.